Cause of action number 1, the Government of Canada violated the plaintiff's rights protected by Section 8 of the Charter, and damages for said violation under Section 24 are appropriate. What's Section 8 of the Charter?
Well, Section 8 is the Charter is the section that protects you against unreasonable search and seizure by government and police.
Right.
But Section 24 is really important, and it's the basis for this lawsuit, because a lot of people don't understand this, because people have been frustrated. I see this online and elsewhere. Well, how come the Prime Minister hasn't been arrested? The federal court, Justice Mosley, said what he did was illegal.
Right.
Well, you only get arrested if you engage in criminal or statutory breaches of law, not other extrajudicial, or rather an act where you exceeded your legal jurisdiction, which is the case here with the Emergencies Act. However, under our Charter of Rights and Freedoms, Section 24 exists to say, if the government violates your rights as a citizen, you have the right to sue the government for damages, and the government has to pay you compensation.
Right.
And the reason is to create accountability.
Right.
Accountability. And we all know that we have lived through a time of a complete absence of accountability by this government.
Right.
For everything from ArriveCan scam to his travel nonsense to I'd be here for an hour just listing off the scandals.
Mm-hmm.
So Section 24 is a mechanism baked into the Charter of Rights and Freedoms. It's made of steel, legal steel. And it says if the government breaches your rights, they're going to pay. Right. And the reason it's there, and the Supreme Court of Canada has made this clear, is to show that the charter rights mean something.
Right.
And that's something that's frustrated a lot of us, lawyers and non-lawyers alike. What happened to the charter during the last 3-4 years? Number 2 is if you've suffered harm through your breach, you're to get compensated. And the third one, get this, the purpose of Section 24 is to deter the government and future governments from stepping on Canadians' rights. So that's why we've sued, and its fundamental foundation is Section 24 of the Charter.
You're right. And let me take a crack at this, explaining it from another perspective, and you correct me if
Sure.
I'm wrong. So if you're in a car accident, you know, the courts will assess, well, how much have you actually been damaged? Well, your car was worth 10 grand and you broke your leg, and we think that's worth 20 grand. So they do the math based on the loss that you've had. Can you quantify it? If you have a breach of a contract, well, how much did you lose? Maybe you can prove it. But if someone breaches your rights, how do you quantify that? It's not the same as a normal tort or a normal contract dispute or a property dispute. So is it correct to say that what Section 24 does is it basically says when you violate freedom of speech or freedom of the press or freedom of association or freedom from warrantless search and seizures, which is one of the issues here, you can't, it's not just a verbal rebuke from the court. You will pay someone because these are valuable, tangible things. Even though they're sort of an intangible right, it's worth something, and you got to pay up. Am I thinking about it the right way here? It's giving
precisely.
Yeah, okay, I thought so, because that's what's been missing the last 2 years,
and that's why I lost these lawsuits today.
Okay, I want to rip through this because we're coming up on an hour here. Cause of action number 2, the Government of Canada committed the tort of interference with an economic interest of the plaintiffs. So that's not necessarily relying on the charter. That's actually, you can quantify how much you've been damaged financially by this, obviously, right?
That's right. And there's also what we call general damages, which are the intangible things that you can't, an accountant can't calculate for you because of the conduct being so egregious and so deliberate that it should attract award of damages.
This litigation will be studied in law schools, I tell you that, because the number of torts, the number of charter violations by the greatest violation of our civil liberties in a generation, that's what it is. I don't think it's dramatic to say that invoking the new version of the War Measures Act is the greatest abridgment of our civil liberties in a generation. In fact, it wasn't even used during 9/11. So I don't think it's dramatic to say that. And so obviously, if you're someone who was abused by it, if it was imposed illegally, which the court has said, obviously you're going to have a festival of causes of action. Next one, the Government of Canada committed the tort of abuse of process against the plaintiffs. I think that speaks for itself. Give me one sentence on that.
by not establishing criteria, by telling banks to look out for anybody wearing a Canadian flag, for telling the banks to collect all the information about your transactions and send it to CSIS and FinTrack and the RCMP.
Yeah. Cause of action number 4, and I think of that interim Ottawa Police Chief Bell, who tried to scare people. Remember that? Here's a clip of him basically threatening to hunt down anyone who donated $10 to the truckers. Here's a clip of this odious man. Take a look.
As I indicated earlier, we will have the opportunity to review all of those files. There are complaint mechanisms for people to enter into if they feel that there is excessive use of force by members of our police service. What I will also say is we have been here for 3 weeks. I have been at this podium for the last 5 days, imploring people to leave, asking them to get out of our streets. This occupation is over. We have advised them that if they peacefully leave, they may go home. That still exists. We also indicated that we would escalate and forcefully remove people from the streets if they did not comply. Some of that is what you're seeing. So I will stand here today again and say, this demonstration is over. Go home. If you don't go home, we will remove you from the streets. If you are involved in this protest, we will actively look to identify you and follow up with financial sanctions and criminal charges. Absolutely.
Yeah, that's not policing. That's something, but that ain't policing. And I thought of it because I'm looking at cause of action number 4. The government of Canada committed the tort of intimidation against the plaintiff's fundamental freedoms under the Charter. Give me a line on that.
This one's really important. And I'm going to steal a couple extra lines, sentences if I can, because it links to other charter rights, which is
right.
I mean, it seems kind of obvious, but I need to say it. And go back to that clip we watched of giddy, twitchy Deputy Prime Minister Freeland. They wanted to scare the leadership of the Freedom Convoy out of the downtown. They wanted to scare them away. They wanted to intimidate them into ceasing the exercise of their Section 2 charter rights of freedom of expression, of assembly, of political dissent. So they were using this tyrannical tool to wipe my clients out from civil society and put the fear of God into them for their ability to provide for themselves and their children and their loved ones and their businesses, for the purpose, the improper purpose, of causing them to surrender their charter rights, their charter right of freedom of expression, political dissent, and peaceful assembly. So that's a really important one. And it exists outside of any charter context because it's an old common law tort. And it's used rarely because you're so rarely going to get these facts, but it fits here.
Yeah. Huh. Isn't that interesting? Well, I think so much of the pandemic policy was specifically designed to be as scary as possible. And I mean, I think of the airport quarantine hotels, which were so atrocious. And I thought, this can't be. And a senior lawyer said, no. It's designed to be as abusive and outrageous so that people squawk about it and people tell 100 friends about it. And those 100 people are deterred from getting on a plane. So the very abusive nature isn't a bug, it's a feature. They made everything here abusive, invasive, punitive, embarrassing on purpose for the reason you suggest, to intimidate.
And add one more thing.
Yeah.
2 days after they did this, February 15th, 2 days after February 15th, February 17th, they arrested Tamara Leach and Chris Barber.
Right.
And put them in solitary confinement on a
days.
Concrete slab.
Yeah. I've had a chance to get to know Tamara Leach a little bit over the last year. We published her book, and we're helping to crowdfund through the Democracy Fund her legal bills. And I have to say that what she was put through is absolutely dictionary definition political prisoner. Absolutely. And even the way they're proceeding on the trial. That trial shouldn't have even proceeded. If it did proceed, it's a half-day trial. The fact that they're stretching it months and months, they're still abusing process. They are still abusing the process, and I certainly hope that her judge sees through it, and I have an optimistic feeling in my bones. Let me get back to your lawsuit. Cause of action number 5, the government of Canada via its public officials committed the tort of misfeasance of public office. Now that sounds old-timey. That sounds like an old-time common law tort. Misfeasance is a word you don't hear that often. What does that mean?
It's when a government official, elected or otherwise, uses their powers for an improper purpose, where they almost gloatingly take advantage of their power. They use it in an abusive way with a harmful and malignant intent. And it's pretty rare. Duplessis was the classic case we learned, Ezra, in law school in administrative law about abuse of power.
Right.
And this is it. This is it. The facts of the conduct of the government of Canada towards its citizens exercising their charter rights of peaceful process and civil disobedience is just so off the scale that these rare torts that we studied in law school 30 years ago fit.